Tonight on the Daily Debrief, opening statements in the case of an Ohio woman accused of killing her military husband. Will she take the stand? Plus, cross-examination of this border-crossing video. Does it show a California family later found buried in the desert? Also, a mid-trial delay in a New Jersey case where a son says he watched his dad kill his mom. That's straight ahead on the Daily Debrief for Wednesday, January 16th. Good afternoon, everyone. Welcome to the Debrief on this Wednesday. Opening statements today in the case of a woman accused of murdering her military husband. Claudia Hoerig is charged with aggravated murder with a firearm over the death of Ohio Air Force Reserve Major Carl Hoerig. Claudia is accused of draining Carl's bank accounts, sending his money to her relatives in Brazil, and practicing at a shooting range before pulling the trigger and killing him. Authorities say she then fled to her native Brazil. Brazil's constitution prevented her extradition, so it took threats by the U.S. Congress to stop processing Brazilian visas to get the government of Brazil to rescind Claudia's citizenship. That's how she wound up back in America for trial. Here is the prosecution's opening statement.
You will hear this defendant say she was guilty of the aggravated murder of her husband and that she should be tried and serve time for that crime in Brazil and serve 30 years. That's what she said. You will hear it. But that statement was taken in 2018, January 17th. A long journey from the time Major Hoerig, who was a 43-year-old veteran who spent most of his life serving the United States Air Force and serving the people of this country in the defense of this country.
The prosecution looped back several times to the defendant's confessions, calling them full of inconsistencies. The state then talked about the defendant's marriage with the victim and even made an analogy concerning the end of the defendant's first marriage.
A statement that puts blame on everybody else but herself. She comes up with endless inconsistencies unsupported with corroborating evidence, circumstances, and frankly, attacks on her deceased husband. They had a rocky marriage. It lasted 2 years. The 30th of June, 2005. Met online. He was divorced for some years, had 2 children. He flies to New York to see her. Within a 2 months or 3 month period, they're married. And she comes to Newton Falls. That marriage does not work out. We will show that Major Hoerig was leaving her. She was a native of Brazil, became an American citizen. She had been married for 10 years to a doctor in New York. She divorced him and didn't kill him.
Objection. Sustained. Disregard that last statement.
Wow, the defense says this entire thing started after a fight over a pregnancy.
We believe the real issue in this case is why. Why did she shoot and kill her husband? As I said, the evidence will show on March 12, 2007, Mr. Hoerig returned home sometime between 9 and 10 in the morning. He'd been out of town a few days before, flying for Southwest Airlines. You can hear that when he came home, his wife, Claudia, met him in the bedroom and advised him that she was pregnant and showed him a pregnancy test. Now, you'll hear from many couples, while this may be a moment of great joy and happiness, for the Hoerigs, it was the direct opposite. You can hear from Mrs. Hoerig that her husband told her, I don't care if you're pregnant, you're not having this baby, I don't want a child. To which you're going to hear her say, why? Why don't you want the child? She's going to tell you Mr. Hoerig told her, my 18-year-old daughter's pregnant, and I'm going to take her child and raise her child so that my daughter can go to college. You can hear Mrs. Hoerig tell you that she told him that she would go ahead and move back to New York and have the child there. She's going to tell you that she told him, or he told her, that you don't understand. I don't want the child. And she's going to say, well, I will raise it and pay for it myself. And she's going to tell you that he told her, you don't understand. I don't want to have the child. I don't want you coming back in the future and getting child support from me. I have to raise my grandchild.
From there, the defense said the defendant started drinking, went for a gun, and fired.
She decided the way to get Mr. Hoerig to talk to her was to take the gun and stand outside the door so that when he opened the door to the bedroom, he saw her with a gun to his head. You're going to hear that she did that in that small little landing that you stood on earlier today in that house. You're going to hear from her that there was indication she wanted to talk with him. They wanted to talk about this. You're going to hear that a small struggle ensued while he attempted to get the firearm from her. She fell down, at which point he told her, that's a good idea. Just do me a favor. Wait till I'm out of here. Go down to the basement and do it so you don't get blood all over my paintings. You're going to see pictures of his paintings that he had. You can hear Ms. Hoerig's statement that at that point he's walking down that very small little stairwell. That he's a couple steps down the stairwell. That he has his shoes on, that they're untied. You hear from Ms. Hoerig at that point, enraged, she stood up, fired the first shot, striking him in the back. You can hear her say that I knew that that shot killed him because he went limp. His leg buckled under him, and he stumbled down the last couple of steps, falling as he lay. His shoes came off. She said at that point that she thought she fired 2 more times at him. You're going to hear from the evidence that there were a total of 5 shots. The shot that killed him, and then 3 shots that were fired from about the same location based upon the trajectory. 2 of which missed and were on the floor. The 3rd shot was into his back as well. You can hear that a final shot was taken and into the side of the head.
One of the first witnesses today was a gun store employee who said the defendant came in with a lot of questions.
She came in carrying a book, the book that most guys are using for concealed carry classes, and she had things marked in her book. She had several questions. I don't remember all the questions specifically, but I tried to explain and answer her questions.
Do you recall what some of the questions were? I mean, you may not remember every one, but do you remember in general or what they were about?
There was, I know she asked about semi-automatic versus revolvers, and she had some questions about ammunition.
Okay. And at the time, did she indicate she was interested in purchasing a firearm?
Yes.
Initially, what type of firearm did she indicate or express an interest in? Did she even point to one?
I remember her looking at a Smith & Wesson Model 29, which is a .44 Magnum. I asked her what she wanted to do with it, and she didn't. She said she didn't want a gun to carry, but she wanted one for protection. And I explained to her that a .44 Magnum isn't good for beginners because of recoil and muzzle blast. It's not something easy to start out with.
And what did you tell her about the .357?
That she could shoot .38 special ammunition in it for practice, and the recoil was pretty low on that, and it was less expensive.
Okay.
Or she could use the .357 Magnum for defense, which had a lot more muzzle blast and recoil, but was more effective.
And ultimately, that witness said the defendant did make a purchase. Joining me tonight on the debrief is forensic death examiner Joseph Scott Morgan. Also here tonight, attorney Marni Snyder. Joseph, let me start with you. I'm sure you were really paying close attention to that discussion of the forensics. It was interesting that the defense brought that out. Sorry, Joseph, I guess we can't hear you. Sorry about that. Marni, let me try to go into you. Interesting here that the defendant basically will testify according to the promise from the defense during the openings there.
Yeah, the defense really promised a whole lot from her, which was really strange because the prosecution says there's absolutely no corroborating witnesses for anything that she's going to say in regards to abuse. So they were on totally opposite pages. We almost didn't hear the overlap of what they might be fighting about. And certainly the prosecution, has their faults too. They seem very deaf to the language of abuse and domestic violence, almost like this couldn't have possibly happened. But the defense doesn't seem to have a lot of stuff to say about some of the evidence that's going to point towards premeditation instead of third-degree murder or self-defense and an acquittal. So it's going to be really, really interesting to see what actually comes out from their promises.
Well, look, it seemed to me that the defense was more worried about knocking this down in severity rather than going for an acquittal. Would you agree that that's the tactic here?
That does seem to be the tactic. And it is hard to prove first-degree murder when there are people who are lovers or domestic partners, because the jury can think about how their passions may be inflamed, and this might have been out of shocking anger and not premeditation. So, I mean, it's definitely a great course to take. But if you're going to go really far with the domestic violence, you have to have something to back that up.
Yeah, I'm curious to see what they have. Marni, Joe, we'll check in with you again at the end of the broadcast. Let's move on now to the McStay family murders in California. Defendant Charles Merritt faces a possible death sentence if convicted in the killings of business associate Joseph McStay, McStay's wife, and the McStay kids. At first, the authorities wondered if the family had gone to Mexico to avoid business debts, but suspicions eventually did focus on the defendant. Prosecutors say he killed the family, dumped their car near the border, and then dumped their bodies in 2 graves in the desert. Merritt's DNA is on the steering wheel and gear shift of the McStay family vehicle. The defense says that's because Merritt and McStay shook hands at a restaurant before McStay disappeared. Today, a detective faced cross-examination about a video authorities believed might have shown the McStays crossing the border into Mexico.
Do you know when you got that video and began viewing it?
I obtained it. It was probably a week or so after the missing persons case began. Once I obtained it and began to look at it, I realized it was overwhelming and that I would need assistance. So it took a little bit longer, and I'm talking days, maybe even weeks, before I actually got NCMEC on board and persons supporting NCMEC to assist me with viewing that video.
Approximately, what would you say it was after February 15th? How long after that?
Before I had put it in front of the family to say this is what we believe?
Correct.
Or this is what we see, not what we believe?
Correct.
A couple months.
Okay. And in regards to what you believe, you had actually told several of the family members that you personally believed that it was Joseph, Summer, and the kids.
No.
You never said that?
No.
Okay. But they would come in and give you their opinion. You had them watch it, correct?
That's correct.
And several family members came in and watched that video.
I specifically remember Michael, Tracy, McIver, Susan, and Blanche, I believe. Also saw it.
Mr. Merritt did as well?
I don't remember him viewing it.
What about Dan Kavanaugh?
No.
And did you testify earlier on direct that it was universal regarding the family that they thought it was? That they thought it was the family?
Objection received testimony.
Yeah, you're lumping them, and maybe if it came across to you that way, each person had a different opinion. Not one person said, no, that's not them.
It's now rather universally accepted that the video did not show the McStays. That same detective previously testified that he entered the missing McStay family's home to take photos. He said he enlarged the photos and that they might suggest, rather, that there were droplets of possible blood on the missing family's table.
Have you, in your career as a police detective, seen blood spatter?
I have.
So what you see in the bottom part of this photograph, you can't say it's blood, right?
I can't say it's blood. It's a horrible moment where I don't know what it is. I did not see it with my naked eyes when I was in the residence at all. And now that the district attorney zoomed it in, it puts a pit in my stomach, but I don't know what it is. I can't say it's blood, and I can't say it isn't blood.
Does blood dry in a specific pattern?
It does.
How does it dry?
No foundation.
Sustained with foundation.
You received training as to how blood spatter or blood will dry.
I went to a 40-hour course by the San Bernardino Sheriff's Department for blood pattern analysis.
Does blood dry in a specific manner?
Yes. How? It traditionally, obviously, dries at where it's the thinnest on an object. If it's blood that's spattered onto an object, the outside or the thinnest edges are going to dry first, and then the thicker or the raised area is going to dry later. And in this, what you see is skeletonized. We call it skeletonized drop of something.
Well, more than one drop.
A lot of drops.
And you said you didn't see it with the naked eye.
No.
And there are reasons for that, right?
Yes, I don't like to make excuses, but there are reasons.
What are some of them?
The reasons for not seeing this with the naked eye, what you're seeing even in this photo where it's not zoomed in, you're seeing the table, and it is highly illuminated right here. There's a reason for that illumination, and it's called a flash.
Testimony in that case will continue into the evening for those of you watching on Law and Crime. Still ahead tonight here on the Debrief. Remember to catch a predator? Well, the man who told a lot of suspects to take a seat in a chair is now in the defendant's chair himself. Plus, new court documents involving Shayna Hubers. She's trying to unring the bell, or the bells, you could say. We explain after the break. Folks, the Kentucky woman convicted of killing her attorney boyfriend is now getting a divorce from the transgender woman she married in prison. Shayna Hubers received a life sentence last summer after a second trial and a conviction. A judge threw out her first conviction because a felon was on the jury. The divorce filing says the woman Hubers married has since gotten out of jail, lives in Arizona, and works as a tattoo artist. The marriage is said to be irreparably broken. Hubers married behind bars last summer just before her trial. That marriage lasted about 7 months. The former host of NBC's To Catch a Predator is himself facing charges tonight. Connecticut prosecutors have accused Chris Hansen of issuing a bad check, which was supposed to cover about $13,000 worth of marketing materials. The alleged bounce check, came after some haggling about the payment, a call to police by the merchant, and a scheduled police interview, which Hansen reportedly dodged. Hansen became famous on the NBC show, which lured suspected child predators into ambush-style arrests. Testimony is on hold in the New Jersey case where a boy who was 12 at the time testified that he watched his father murder his mother. Defendant Jeremiah Monell faces charges including first-degree murder over the death of his wife Tara O'Shea Watson. Prosecutors say he stabbed her more than 40 times. Monell's son says his father fled after telling him he shouldn't have seen the crime. The case is delayed so the defense can prepare evidence. A DNA analyst placed the defendant's DNA all over the crime scene along with the victims. But the defense did bring up some key points the other day about unknown DNA and the lack of the defendant's DNA on the knives believed to be the murder weapons.
Monell is identified as the source of the DNA profile obtained from specimen number 23, which was a partially burnt cigarette.
But he was excluded from specimen number 22. Is that correct?
Yes, both Tara L. O'Shea Watson and Jeremiah Monell were excluded from 22 and 24.
And what were they?
22 and 24 were both partially burnt cigarettes.
So just to clarify, that means that neither one of them were the contributors from those cigarettes. Okay?
That's correct.
What was 30-1 and 30-2?
30-1 was knife swabbing from the blade, and 30-2 was knife swabbing from the handle.
Was Jeremiah Monell the source of any of the DNA contributors from that handle or that blade?
No, Tara L. O'Shea Watson was identified as the source of both of those samples.
I also noted on your thing that says that you submitted sample specimens 22, 23, and 24 to CODIS. Is that correct?
Yes, that is correct.
And why would you do that?
Those we would be submitting to that database to identify possible contributors to those samples.
In this particular case, did this submitting these samples, did it return any results?
Not to my knowledge.
Joseph Scott Morgan back with us tonight along with attorney Marni Jo Snyder. So, Joseph, this is an interesting case because this DNA testing may throw the big wrinkle in it that no one was really expecting.
Yeah, it could potentially do that, but let's just keep in mind that there's any number of reasons why his DNA would not necessarily be found on the handle of the knife itself. You know, if he was gloved in any way or if he was barriered in any way relative to his own DNA. And let's also keep in mind there was a copious amount of her blood spread all over this area, including multiple surfaces of the knife. So that could go some distance to explaining this.
Exactly. Marni Jo Snyder, we've got a couple of seconds left. A lot of people are saying, look, this is probably still not enough for an acquittal in this case, but you never know.
Right. I mean, you just say burden, burden, burden. They have to prove it. His DNA is not on the knife. No one else's is, but that, you know, it doesn't add much to the prosecution if there's no DNA there. So anytime there's a hole and they can't meet a burden, that's great for the defense.
Exactly. Well, we've got eyewitness testimony that this is the defendant who did it, so that's going to be tough for the defense to overcome. Joseph, Marni Jo, appreciate you joining me on the debrief tonight.
Thank you.
All right, we're just about out of time. A reminder for those of you watching on the Law&Crime Network, our live coverage of the McStay case and the Hoerig case will continue in just a moment. For those of you watching on Cox media stations, have a good evening. We'll see you back here tomorrow on the Law&Crime Network from 4 to 4:30 Eastern with our recap of the day's legal news.